During jury deliberations in a civil lawsuit here in New York, if the jurors have questions, can they speak to the judge privately? You want to know the answer? Come join me as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney, and the answer is yes and no. So let me tell you what I mean. It's now the end of your trial. Maybe it's an accident matter or a medical malpractice matter or even a wrongful death matter. The jury now goes in to determine whether you are more likely right than wrong than what you are claiming is true. But the jury's confused. They didn't understand something the judge said during his instructions, giving them the legal instructions. And now they want to speak to the judge privately. Can they do that? The answer is yes and no. So here's exactly what will happen. The foreman of the jury will write a note to the judge. They will take that note, give it to the court officer who's standing outside the jury deliberation room. The court officer will take that note, give it to the judge. The judge will then read it. He will then call the attorneys up to tell them he's gotten a note from the jury. This is what it says. The jury wants to speak to him privately. So now the judge is going to go into the jury deliberation room to find out what the problem is. Now, once he learns briefly what the problem is, he's now going to come back outside to the courtroom, speak to the attorneys, and formulate a plan of action. Now, the one or more of the attorneys may object to his plan of action. At least in open court, we have the opportunity to make the objection, have a court stenographer put it on the record. So if we have to appeal, now it's already on the record. In all likelihood, the judge will have the jury come back into the courtroom, and now he'll go ahead and give further explanations about the issues that they're confused with. And once that's done, he'll tell the jury go back in and continue deliberating. That's a much better practice than the judge being in the jury deliberation room privately, without any court stenographer present, without the attorneys being present to hear and to listen to what was going on. The better practice is to have them come back into the courtroom, formulate a plan of action, and now have the judge explain to the jury in open court exactly what they need to focus on, and hopefully that will resolve the issue. So why do I share this quick information with you? I share it with you just to give you an insight and an understanding into what happens in these civil trials here in New York. You know, I understand you're watching this video because you likely have questions or concerns about your own matter. Well, if you're thinking about bringing a lawsuit but have not done so yet because you have questions that need to be answered first, what I invite you to do is pick up the phone and call me. I can answer your questions. You know, this is something I do every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.